Good morning, everybody, and welcome to our Senior Law Day program this beautiful Wednesday morning. This morning, we're going to be presenting on how to use a power of attorney and when to establish a guardianship. And we have a fantastic speaker, Joseph M. Accetta, who is the court attorney referee in the adult guardianship part for the Westchester County Supreme Court. So without further ado, please welcome Joseph Accetta. Thanks so much.
Good morning, and thank you. Thank you for that nice introduction. Good morning, everybody out there. I am happy to have and spend an hour with you talking about some very important information. Some information that's actually evolving as we speak, and I'm going to touch on some of those things. Basically, I'm here to talk to you about what we in the guardianship part, which is where I am. I'm a court attorney referee here in Westchester Supreme. And I handle adult guardianships that come in here under the Mental Hygiene Law, Article 81, for people who pretty much are starting to slow down in their lives as the aging process takes over. People typically affected with dementia and other ailments, some physical, some mental, where a person now needs to determine whether, or a court may need to determine whether a person needs assistance. And what I'm here to sort of discuss with you are the ways in which you can avoid that trip to the court. If it becomes inevitable, I will also tell you about how to best navigate your way through that trip. But the key, and part of the title of the program that we're dealing with today is couched in what's called a power of attorney. It's an advanced directive that you execute while you have the ability to do so and the capacity to do so, much like you're executing a last will and testament. And you typically pair up a power of attorney with other documents, one of which is called a healthcare proxy and another of which is called a living will. Okay, and I'm going to talk briefly about all of those items and what they mean in terms of a potential need for a guardian and a guardianship in my court here in the Supreme Court, the mental hygiene adult guardianship part. Now, the power of attorney is evolving as we speak. Only in the last couple of months, and the current version of a power of attorney is about 11 years old, 11, 12 years old. I think it was last revised in either 2010 or 2011. Well, it's being revised again as we speak. In fact, later this month, the newest form of the power of attorney will take effect. And a lot of the changes in the power of attorney result from what was supposed to ease a lot of the confusion in executing this document. Didn't really do so the last time around. Another document was added whereby you couldn't make gifts over a certain amount of money unless you executed this specific rider, and that's being eliminated. And the power of attorney, again, they're trying to get down to the basic functions. And a power of attorney is something that you, as a principal, allow a person you appoint or people you appoint. You can have multiple powers of attorney who can either act separately or they can act jointly. And they are your agents. And you can appoint them for activities. And these powers of attorney are typically financial or business-related activities, as opposed to a healthcare proxy, which is for personal needs and usually for medical decisions. And I'll talk about that in a minute. But the power of attorney has a fairly lengthy checklist of powers that typically are business-related and finance-related. And you are perfectly capable of allowing somebody who you designate as an agent to act while you have all your faculties. You just designated them to act in your stead because either you have a schedule which doesn't allow you to be in too many places at once, or just for the convenience of it. In some instances, the power of attorney is also durable, which means that the powers survive your disability. In other words, you make the power and create the power of attorney while you have your faculties, and a durable power of attorney is meant to stay in place when you no longer have your faculties. And that's when the agent really begins to act. And that's kind of the demarcation line we look at in the guardianship part to see if the power of attorney was validly executed and was executed at a time when you had your faculties to do so, because most of those powers of attorney are indeed durable and are supposed to, in essence, survive your loss of your ability to function in terms of finance or business transactions. So that's the durable part. The only thing that's certain about the power of attorney is it ceases upon your death. The agent can no longer act once you die. In essence, the power of attorney stops becoming an effective instrument at that point. So again, the legislature saw that many banking institutions were refusing the most current version, which is about to be eclipsed, and because they weren't properly executed, and because they lacked the gift rider, which is typically needed in one of the indelible functions one designates their agent to do, which is to make gifts on their part. Of course, the gifts have to be, they can't be self-serving gifts, because there's case law in our state which forbid those types of transactions, and they come under the scrutiny of a court in many instances. That's not something that you want to do when gifts exceed a certain amount of money. So the power of attorney, again, is something that you want to determine if you want to designate an agent or agents to transact your business, both while you still have your faculties to do so and when you no longer have your faculties to do so. And again, if you have a current power of attorney, you don't have to replace it, but as with any other advanced directives, it's a good idea to sort of review your inventory of those documents every 2 or 3 years. Some practitioners may say 3 to 5 years. Having been in the court and seeing how people can rapidly decline, I would suggest, a 2 or 3 year time period may be more appropriate. And you want to review those documents, and perhaps you want to execute the new version among your other documents when you're doing your next document review. So there are, again, one of the reasons underlying the change was because many banking institutions were looking at improperly executed powers of attorney, or they simply were refusing them and not giving good cause. And that's no longer going to be acceptable. And there will be a presentation by this organization for your benefit, I believe coming up at the end of June, by which will be used to review the implementation of the new power of attorney form, as well as a lot of the bells and whistles that go along with the implementation of that form. So I would suggest that if you're interested in that, you should sign up for that and attend that webinar. In fact, Sarah's going to give you a bit of information on it, I think, at the moment.
Thanks, Joe. So that webinar is going to be presented by attorney Deep Mukherjee, which is going to be on June 30th. And we're going to have a registration link on our website shortly. So if you want to get all the details about the new power of attorney law and new power of attorney form, we're going to be hosting that program again on June 30th. But Joe, we actually have a question on the power of attorney that came in. And our question asker says that they have a durable power of attorney in place, but what happens if the bank doesn't take it? Can they insist on using their own form?
Well, this is where many people unfortunately have to turn to the guardianship court, and this is unfortunate. And this is what the legislature is trying to address, this type of problem. Financial institutions are very fickle when it comes to this. They shouldn't be. And under the new law, financial institutions will be penalized in the event that they don't demonstrate a good cause for rejecting your power of attorney. Again, those are details that I'm going to leave for Deep when he does his program on the power of attorney on June 30th. But again, we find this often. Banking institutions, if you have to come to court, sometimes you need court orders to force banking institutions, not necessarily to accept the power of attorney, but to do transactions with the guardian. And it's unfortunate that you may have to very well bring a proceeding for a guardian if the financial institutions you're working with aren't accepting the forms. A lot of them want you to use their forms so that they can, in essence, ensure that you're going to do business with their organization. We are powerless to stop that in terms of the court. We don't get involved in that. The court only gets involved when you have nowhere else to turn, and the circumstances, again, may very well warrant that we bring in that institution in a guardianship proceeding and we grill them and say, why aren't you accepting this? From what we can see on its face, it wasn't improperly executed. It seems to meet the standards that the general obligations law provisions in New York State's laws provide. So unfortunately, my answer is, a lot of times you're beholden to the whims of the financial institution unless you want to come to the guardianship part and get a guardianship. Hopefully that will change with the implementation of what's a form that really purports to be much simpler in form, and also the statute has been amended to sort of put it to these institutions to make sure that they're denying your instrument, and if they don't demonstrate good cause for doing so, they could be penalized. So that's one way that the legislature has addressed this issue. Okay, Sarah?
Yep. And okay, to answer a quick question that came in, June 13th is the day for the new form. So if you are doing a power of attorney June 13th or after, use the new form. If you already have signed a durable power of attorney and it was signed with the old form, it's still valid as long as it was properly signed and executed at the time that was the current form.
And just like anything else, when a law of this nature changes, there'll be a phase-in period, and the financial institutions you'll be dealing with may give you some pushback. But I think they're all now mindful of the fact that the legislature is going to be less tolerant of the pushback unless the pushback has a legitimate basis. So hopefully that goes well. But there will be a transition period with respect to the implementation of the new document. And again, I strongly suggest that you sign up for Deep's presentation on June 30th. And I know I've been to a couple of presentations given by some really prominent elder law attorneys here in this state. And there's a lot of nuances that you should be aware of. And a lot of those nuances are actually beneficial to you as the principal and also to your agents. So I don't want to spend too much time on the power of attorney. I do want to get to the guardianships, but in order to do that, you got to be aware of these other advanced directives that I mentioned at the very outset of the presentation. And those advanced directives are a healthcare proxy, and the provisions of that are governed under New York's public health law, and a living will, also governed under the public health law. Okay, and I want to spend a few minutes addressing what each of those purport to cover. A healthcare proxy, in New York, you can only have one healthcare agent designated at a time. You can have alternates, but only one can act at a time if you're executing the proper form of a healthcare proxy in New York. And the healthcare proxy is used for you to designate somebody whom you want to make your medical decisions in the event that you're no longer able to do so. It kind of works somewhat similar to the power of attorney in terms of your financial decisions and your designation of an agent to make those decisions for you. But typically, you're going to be dealing with medical staffs and medical personnel who are going to want to deal with you until they make a determination that you are unable to advocate for yourself in terms of your health issue or a specific health question. And that's why it's always good to have a healthcare proxy in place and to have that designee regularly communicate with your medical personnel, whether it be your internists or whether it be hospital personnel or the like. And again, the power of attorney and the healthcare proxy sort of go hand in hand because one addresses your ability to do financial transactions, and that's the power of attorney. The other addresses your ability to make determinations with respect to medical decisions, medication-related decisions, and this is all sort of a precursor of what you could expect in the event you don't have valid documents of this nature in place, and you're losing your ability to make those determinations in your own right. The living will is, in essence, a backup to a healthcare proxy. It's a continuation of the decisions that you want your agent under the healthcare proxy to make. But those decisions are really end of life decisions, where the topics of intubation and feeding, intubation, respiration, all of those vehicles, while you have your ability to make that determination, you want to put in paper what your thoughts are in the event you're forced into a situation where you're nearing the end of life and the medical personnel need to know whether or not you are authorizing them to keep you alive by artificial means, whether to intubate you in terms of feeding, and you have every right to make that determination. And typically, the person who you name as a healthcare proxy is also the person who you designate to carry out the parameters of what your wishes are as you set them forth in your living will. So that whole package of documents, really those three are the primary. Sometimes if you're admitted to a care facility, you're asked to do that type of document. And somebody's asking who makes medical decisions if you don't have healthcare proxy or a living will. I'm going to address that in a second. But those documents should really be on file, and you again, the agent that you designate under the healthcare proxy and the nominee who you indicate in the living will should really be communicating with medical personnel. Now, a very good question just came across the chat. Who makes those decisions if you don't have a living will or a healthcare proxy? And if you aren't able to make those decisions, there's something in New York, and quite frankly, it's been a godsend. And it's about, I'm going to say, roughly about 10 or something years old. It was the Family Healthcare Decisions Act. And in essence, it gives a roster of people in a specific order of usually family members. Sometimes it's a designee as a guardian, and we're going to get to guardianship shortly. But it's usually family members who are able to deal with the medical personnel to make those decisions for you. Now, medical personnel, of course, would prefer to have a designee, an agent under a healthcare proxy. They'd rather have instructions in a living will. That's not always the case. People don't often plan far enough ahead to execute those documents. The Family Healthcare Decisions Act is sort of a safety net for the lack of the existence of those documents. And family members, in essence, are able to communicate with the medical personnel when medical personnel reach out to them, and those decisions get made by family members. The bottom line here is, if you want certain family members to make those decisions for you, you may not have a choice if you don't timely execute a healthcare proxy and a living will. You're going to get stuck with family members who you may not want to make those decisions for you, and the medical teams and personnel aren't going to know any differently. So that's why you need to sort of take command of your own destiny when it comes to these types of scenarios. And you want to have a healthcare proxy with a designated agent and a living will with a designee to implement those decisions for you in place, just like you want to have a power of attorney in place with respect to financial decisions. Okay.
We have a question that came in, just a terminology question. So our participant asks, is an advanced medical directive the same thing as a living will, or is one a subcategory of the other?
Well, in the guardianship part here in the courts, we sort of group under advanced directives. We group, and you've used the term advanced medical directives, but we use advanced directives for these three documents, okay? Power of attorney, healthcare proxy, living will. Advanced medical directives are certainly include and are comprised primarily of living wills and healthcare proxy. So in terms of terminology, yes, but when I'm speaking of advanced directives, I'm also including the power of attorney, because we also, in the guardianship part, those are documents that we need to know either the existence of or whether they were properly executed in order to determine whether or not a guardianship is necessary. I'm going to transition into that analysis now. So
three separate documents, correct?
Three separate documents, all of different import, as I've explained, but all of significance when it comes to whether the Supreme Court is going to make a determination that you need a guardian appointed under the mental hygiene law provisions of Article 81. Okay, so let's assume that you have properly executed a power of attorney and the agent is still alive and well and carrying out your wishes under that document in terms of your financial transactions and your business transactions. Let's further assume that you have a properly executed healthcare proxy and a living will in place. Most cases, when you start to fail in terms of your ability and you become, in essence, I would kind of loathe to use the term victim, but you're compromised now and your ability to self-determine is compromised by the aging process. You want to have those documents in place so that the people who have the right to come to this court, who are typically family members or close friends if they're in the absence of family members, or in some cases, and in fact, in many cases, if you are in a healthcare facility, such as a nursing home or an assisted living facility, the administrators of those facilities have a right to come to the court to ask that a guardian be appointed for you. And that's typically when you're dealing with the administrators of those facilities, it's usually because they're unable to get enough information from you to make a determination in order to properly see if you can qualify for public assistance, so that if the facilities aren't getting paid, then public assistance can step in. And I'm talking about Medicaid here. And Medicaid can cover a lot of the expenses that you are unable to make on your own. But when you are unable to provide that information to a care facility, the care facility has standing in this state to come and ask the Supreme Court to appoint a guardian for you. Now, a lot of times, because you either a lack of family members that are involved and you're unable to provide information to the administrators of the care facility doesn't know whether or not you have advance directives in place. And that often becomes the job of a court appointee in the context of a guardianship proceeding to pursue. And that court appointee is called a court evaluator. And that's a person the court designates to investigate your finances, your medical condition, and whether or not these advance directives exist. Because if they do exist, that mitigates against the appointment of a guardian. And what will happen, again, in the situation that I'm talking about when you're dealing with a care facility, then the designees under those documents, the agents are then, the care facility is directed to deal with those people. If those people, your agents, are not diligently acting on your behalf under those instruments, the mental hygiene law specifically gives the Supreme Court the right to revoke those documents. Okay, so not only is it important that when you're creating powers of attorney, healthcare proxies, and living wills, that you designate somebody that you trust and is trustworthy and is somebody who's responsible and you know is going to carry out your wishes and is going to advocate on your behalf every step of the way. That's just as important as properly executing the documents in the technical term of it. Otherwise, if you have somebody who's not cooperating, who's named, and there are instances where a care facility, such as a nursing home or assisted living facility, will come to this court and ask for a guardian for the very reason that the person named in a power of attorney or in a healthcare proxy is not cooperating with that facility. And they have no other choice to turn to in order to get what they need to get done and to have the decisions made that need to be made for the benefit of the person whose ability is now compromised. So it's important, again, that if you're going to do those documents, you certainly want to do them correctly in terms of the technical completion of the documents, but you also want to pick agents who are going to be responsible and people who you're familiar with, whose nuances and whose idiosyncrasies as well as their level of responsibility. Because if they're not acting under those instruments, then you've done the work and spent money to put those advance directives in place, and they're not going to ultimately prevent a guardian from being appointed, because this court would have no choice but to make a determination that the agents were not acting diligently or properly under those instruments, and therefore the wherewithal or the health or the financial situation of an alleged incapacitated person has been compromised to the extent that the agents appointed under those documents are not acting effectively, and therefore the court has the right to revoke those documents and put a guardian in place. And that's something that you have to contemplate. Now, getting a guardian in place is not necessarily, the end of the world. In fact, Mental Hygiene Article 81, which I believe has been around about 30 years now, was specifically tailored to have powers, not all-inclusive, but selective powers that a court can impose with respect to your personal needs and your property management, so that they're the least restrictive means. That's what the statutes provide for. The court is not looking to lock you up and to put you in a personal prison so that somebody does everything for you. The court is looking, ultimately, when a guardianship proceeding is brought here, the court is sizing you up and assessing your mental capabilities to see whether you can perform what we call your activities of daily living, ADLs. And ADLs typically boil down to your ability to cook, to clean, to toilet yourself, to ambulate, to get around, to do a checkbook, to be able to read and to maintain a checkbook. And those are some of the ADLs. There are numerous others that a court will assess. And in a guardianship proceeding, it typically doesn't become a battle of medical personnel in terms of the witnesses that come in. In fact, the witnesses that are called in virtually every guardianship proceeding are social workers, people who have observed you and are able to testify as to your diminishing capacity, or whether you're able to perform your ADLs in a meaningful way. Also, the court would assess whether you can meaningfully participate in the proceeding, which means, are you able to communicate with the court? Are you able to affirmatively state at the time of the guardianship proceeding what your preferences are, whether you consent to assistance? That is something which you don't have to necessarily, many people fear guardianship because they ultimately think that the court is looking to make a finding that you're incapacitated. Well, incapacitated is a statutory definition in our mental hygiene law, and it basically means that you have functional limitations to some level, and you don't understand the import of those functional limitations. It doesn't mean that you've gone off the deep end. It doesn't mean anything beyond what I just said it means, which is you have functional limitations, which may be preventing you from performing your activities of daily living, and may endanger you at some point because of your inability to perform those activities of daily living, or to understand the import of your inability to do those activities. And more importantly, it's your inability to comprehend those limitations. And when a court makes a finding of that nature, that's when you're classified under the mental hygiene law as an incapacitated person. It's strictly a statutory definition. Sarah?
So we had a very interesting question that came in, and our participant says that they appointed a guardian in their estate planning papers. Is that enough?
Very good. And when you say your estate planning papers, I'm assuming you mean either in a will or some type of deed by which you appoint a guardian. It's typically done in a will. For those people who assume that the minute you sign your will, it becomes effective, that is far from the case. And I typically give a presentation every year, either in person or in the last couple of years online, regarding wills. And a will only becomes a will when a court says that it's a valid will. You may think it's a valid will, and any provisions in the will are subject to approval by the court upon the will being offered to the court for probate. Now, a provision appointing a guardian is not necessarily something that the court will ignore, but if it's in a will, the provision can't be honored unless the will is admitted to probate. Okay, your thoughts and your hopes and your desires are all set forth in the will, but those don't become concrete until the will is admitted to probate. So appointing a guardian is instructive. It's not determinative until the will is actually admitted to probate, and you need to understand that. So depending on what court you wind up in, whether it's my court, the adult guardianship part here in Supreme, or a surrogate's court, which also has guardianships for people who are either developmentally or intellectually disabled, as well as for infants. And I spent 20 years in the surrogates court, so I'm very well versed in what the requirements are for that. They're quite different in terms of the requirements for a guardian appointed by a surrogates court as opposed to a guardian appointed by the Supreme Court. The Supreme Court is typically for adult situations where, again, the aging process has kind of set in. Very rarely will the Supreme Court guardianship part deviate from that. I have a question here. What is the difference between a POA and a will? Very good question. A power of attorney, again, is a document you execute while you have your faculties, and you designate an agent to act for you while you're still alive. And again, that agent can, and powers of attorney, again, are pretty much limited to financial and business type transactions. And that person acts as your agent in those transactions while you're alive. That person can act not only while you have your faculties, but in situations where you execute what's called a durable power of attorney, that person also acts for you once there's been a determination, or once you're unable to carry out your own functions, and you designate that person to continue to carry out those functions for you at that time as well. A will is, and when I say will, I'm talking about a last will and testament. That's where you typically set forth how you want your assets to be distributed upon your death. And if you don't have a will when you die, it doesn't mean your assets don't get distributed. It means they get distributed pursuant to a statutory framework that New York State has under its estates, powers, and trust law. And then typically your assets, if there's no will, would go to family members depending on their degree of relationship to you. If you have a spouse and children, then that's pretty much going to be the limit of who gets your assets. If you don't have a spouse or children, then the statute begins to look down to parents and grandparents and siblings and nieces and nephews and so forth. So that's the difference between a power of attorney and a will. And as I said earlier, the power of attorney ceases to be a viable document upon your death, as opposed to a will, which you're hoping becomes a viable document subsequent to your death, provided that it's offered to a surrogates court for probate. Okay, you're welcome. So again, just circling back to guardianship, I've raised some scenarios where, again, people are afraid of the determination of a guardian because they believe that they're going to be carrying around a stigma of incapacity. That's not necessarily the case. As I said, the term incapacitated person has a limited definition, and I explained what that definition is. But there's also, you can come to this court if you don't have advance directives in place and you realize that you're slowing down in life and perhaps you do need some help. And a person who does that and is still able, upon a court's sort of give and take with you, the judge will probably bring you back and have an in-camera interview with you to make a determination as to your functionality level and the ability of whether you can provide a knowing consent. You can consent to the appointment of a guardian. And again, I'll talk about the powers in a second that the court can tailor to a guardian. But in that case, you're not deemed to be incapacitated by definition. You're deemed just to be a person in need of a guardian. Sarah, did you want to say something?
Oh, I just wanted to, to tell everyone that the court is a really friendly place for guardianship, and that the court focuses on the person's abilities. So it's not just what they cannot do. So it's an important tool to use if you don't have advanced directives in place. And the court is also an important place to look to for help. So this should be a really positive service to the community.
It typically is, Sarah. Thank you for saying that. I know that we do a lot of outreach. I speak to a lot of senior groups. I have over the years. And again, the court is not looking to stigmatize you in any way. The court, quite frankly, we have judges here who ultimately wind up, sternly educating your family members about your needs. It should not be about them. It should be about your needs and your limitations and the way in which those limitations can be met so that you have the best quality of life as you're going through the aging process and you're moving along. And that's why some of the buzz phrases in the statutes and the mental hygiene law talk about the least restrictive means. You know, the court is not looking to impose powers that you don't need. The court, that's why the court takes testimony from people who are seeing you and observing you and living with your struggles, so that they can properly determine whether this person needs to have somebody pay their debts and bills and taxes, whether they need a person to determine, and that's on the finance side. On the personal side, one that always is important is whether that person needs to have somebody determine what their social calendar should look like. You know, whether or not you need to go to day programs in order to have appropriate socialization, so that you're not being shut down in life. You're not being shunted away in your apartment or in your room at a care facility, that you're engaging in whatever social components your abilities allow you to do. And that's become really pronounced in this last year and a half, as we've sort of, we've muddled through this COVID period, where a lot of people have become isolated and not of anybody's doing. And the court's ability to step in has been compromised by a lot of the COVID restrictions. And we've tried to overcome that as best we could, working with the facilities in terms of the limitations that have been imposed upon them by the provisions of the CDC and the governments that have been making those decisions in terms of your ability to socialize, not only with family members, but with other people who are similarly situated with you in those care facilities. And we've very proactively been involved in situations where people have come to us in an existing guardianship, and we've had to get involved, and we've had to basically tell personnel in some instances, and when this has been asked for us, we've had conferences where we've spoken with administrators to try to alleviate any isolation and to have their staff members perform their duties in the safest but most meaningful way possible for the benefit of the residents of these facilities. And that's not easy. And again, it's something that the court has to be respectful of the other branches of government that it stepped in. But Sarah saying, that the court is concerned about the person who is being brought to the court for assistance is genuine. And we have judges that are very concerned, at least the judges I've worked for in my 6 years in this part. All the judges have been very concerned and very proactive in that respect. And they are not going to impose powers upon you unless they believe that the functional limitations that have been brought to the court's attention merit those powers for a person that's going to be appointed as your guardian. Sarah?
Great. So we have a question that came in that I think we're going to address on our June 30th program. The individual actually sent an email saying, a financial institution told me last week that they would not accept my power of attorney. They want their own form filled and notarized. Will that be the case next month? And we're going to answer that question for you on June 30th, but also on our website at the end of the program, we're going to highlight our Ask Us button where we can set up a one-on-one consultation for those sorts of specific questions.
Okay, thanks, Sarah. And again, that's something that's best left to the practitioners who are out there seeing what you see. Again, the guardianship part in the court that I work in, we get involved in that situation occasionally, but that usually means that we have to bring somebody before us who isn't doing what they should be doing in terms of honoring the document. Okay. Somebody's asking a question in terms of the power of attorney signed in New York would be valid in all US states, and that's not necessarily the case. Some states honor documents that are executed in other states, others do not. They are not beholden to do so, which is why if you are a snowbird, for instance, you probably should have a couple of sets of documents, one executed in Florida, one executed in New York, because we've had situations where those documents have been challenged. And I don't like to use Florida as and say that Florida is the sole culprit here, but other states have had this issue, and we've had Other states not accept New York documents, we've been told, and New York has not accepted documents from other states. And it's merely because of the way the documents were executed. If the document in the other state is executed in a manner consistent with the execution parameters that New York statutes call for the same document, a New York court is going to tend to accept that document. But not all states have the same requirements for the execution of these advanced directives, which is why you need to be wary of that. And if you are somebody who's drifting from, well, drifting, not necessarily drifting, but traveling from state to state, and not really sure where you're going to wind up, you need to be mindful of that as you're preparing these advanced directives. So, as I said, to sort of circle back and tie a bow around the guardianship process, typically family members are involved. Again, the administrators of care facilities get involved. Sometimes the county, the Department of Social Services gets involved. Usually when there are adult protective service reports that have been rendered and investigations rendered. Again, it's all for the protection of you, the individual, when you're in a position that your faculties are beginning to fail, and it's usually due to the aging process, or even in some cases, some type of traumatic brain injury. But again, if the court evaluates you and sees that you are able to participate in your destiny in terms of making healthcare decisions, in terms of being able to perform a substantial amount of your activities of daily living, but you are and you are capable of acknowledging your own limitations and consenting to help, you're not going to be deemed to be an incapacitated person, if that's what you're concerned about. You will have a guardian appointed for you. That guardian will be given limited powers and will not be able to exercise those powers unless, and the court will actually put this in its written judgments, unless they've had a full consultation with you. And again, the guardian ultimately is making the decision, but your thoughts and desires are to be expressed and discussed and taken into consideration when the guardian exercises the powers that the court ultimately assigns. And the powers, again, they have a fairly full range for personal needs management. Typically, we're talking about making either basic or advanced dental or medical decisions, executing a do not resuscitate or do not intubate order if no living will exists. And that usually doesn't get done without prior court approval. A guardian just can't execute that document, has to present that document to the court for its review. The guardian also usually, again, if you're incapacitated, will be able to choose your healthcare providers. Usually most guardians will go with the healthcare providers that are already in place, assuming you have a network of healthcare providers in place. They will determine, again, your social calendar or participate in determining who may visit or who may not visit you. And it's often not a matter of the guardian barring people from visiting you, but it's going to go by the wishes of the person who's incapacitated. So you may very well be a gatekeeper in that respect, to some extent. You also will be empowered as a guardian, typically, if a guardian is appointed, to make sure that your government and private benefits are all up to date. And if you're entitled to additional government and private benefits, which you're not getting, then to apply for those private or government benefits. Typically, you're allowed to access what are your personal records, whether they be psychological, medical, or financial. On the finance side, again, you're typically establishing a guardianship bank account. You're paying bills, debts, and taxes. You're establishing a prepaid funeral trust if one isn't already in place. You're able to hire professionals such as attorneys or accountants to bring and defend against any litigation that a person who now needs a guardian may be involved in. And again, there are many, many more powers, but the court, and I go through this process with the judge, when he usually renders a decision right on the record after a hearing, we will go through a checklist of the powers that are appropriate, and it's not mechanical. It's, well, we heard testimony on this, and this person can get by without that. So The judges who do this tend not to be over-inclusive of the powers because they want the people who come before the court who ultimately need a guardian, whether they're deemed to be a person in need of a guardian or ultimately an incapacitated person as defined, again, the limited definition that I gave you earlier in the mental hygiene law. They want those people to be as autonomous or self-autonomous as possible. And I can assure you that that occurs. It occurs, we're involved in guardianships not only here in Westchester. To some extent, we back up the other 4 counties in our judicial district here in the 9th Judicial District, which are Putnam, Orange, Rockland, and Dutchess. And we do a lot of the compliance work to make sure that the guardians are properly accounting not only for your money and how the money is spent and your income is collected and your money is spent on your behalf, but also whether or not your medical needs are being properly addressed and whether the guardian is actually coming and visiting and communicating with you as the statutes require. So to sort of tie a ribbon around this whole presentation, you're in a position where you can dictate your own fate. And if you're in a position to do that, where you have your faculties are not questioned right now. Again, I'm not a practitioner. I'm not here to give you legal advice, but I can tell you that from the court's point of view, once a guardianship is established, it carries with it a lot of bells and whistles that involve coming back and forth to court. The initial guardianship is not the end of the story. It's usually the beginning. And we have annual accountings that have to be looked at. We have applications that have to be made in order to hire professionals. If a significant expenditure is going to take place on your behalf, your guardian has to come to this court. If they're going to sell your real property, the guardian has to come to this court for approval. If they want a DNR or DNI type of order put in place because there's no living will, the guardian's going to have to come to this court for approval, and it becomes a continuum. Okay, so the younger you are, because this court is really about the aging process, the younger you are and the more it's apparent that you have your mental faculties, this is something you should take care of, and you should take care of it upon consultation with your family members. You need to probably consult with a professional, which is a good idea, who's going to want to know what the dynamic is with you and your family members so that they can tell you whether the choices you're making as your agents under these documents is an appropriate choice or something that's going to lead to further trouble. And that's okay. It's, you've got to come clean in terms of, what your family history is. Otherwise, this doesn't work. And the documents you execute are ultimately not going to be to your benefit, and they're ultimately not going to prevent the imposition of a guardianship for you, because either the documents weren't properly done, they weren't done at all, or the agents you selected under those documents are not carrying out their fiduciary responsibilities on your behalf. And that's what this court looks for. That's why the minute we have a guardianship proceeding brought here, the first question we ask is, well, what advance directives, if any, exist? We need to know if there's a power of attorney. We need to know if there's a healthcare proxy. We need to know if there's a living will. And more importantly, we need to know who are those agents, because they're going to be brought in to court, and the court has the right to question them about the way they are conducting their business on your behalf, because you've designated these people as your agent. And the court ultimately has to make a determination as to whether or not the advance directive should stay in place in lieu of a guardianship, because you've made the right decisions about not only executing these documents, but also to choose the agents that are going to be acting in your best interests, so that the court doesn't have to revoke those documents and impose a guardianship upon you. Okay, so that's the interrelationship between, and I sort of broadened the scope of what you were expecting here, I'm sure, when we talked, I believe this was advertised merely as power of attorney. You see that these other documents are indelibly linked to this process. And whether, your either execution or lack of execution of these documents is ultimately going to lead to a guardianship. And I hope I've addressed those issues sufficiently for your purposes today. If there are any questions, Sarah, I'll be happy to take them along the way. I'll be happy to take them now.
Okay, great. So if anyone has questions regarding guardianship, please enter them into the Q&A so Joe can answer them for you. We had a very specific power of attorney question come in, and we're going to give that question to our presenter for our June 30th program. So this may be a question for our other program, but I'm going to give it a go, Joe. So the participant asks, why does Social Security insist on a payee rather than a POA? How is that addressed in guardianship?
That's a good question. I'll be honest with you, and that doesn't necessarily make or break a guardianship, okay? The representative payee, which is the term of art that Social Security uses, is usually the Social Security want to make sure that there's somebody there that's receiving the check if they know that there may be an issue. In many cases, the care facility wants to be the representative payee because they want to ensure that they're getting what, at a minimum, what they're entitled to. It's called a NAMI, N-A-M-I, and it's basically a minimum payment of your income, a minimum portion of your income that goes to the care facility in lieu of full payment of what you owe to the care facility. And it's all tied into Medicaid. It's all tied into government assistance. And that's probably best left to discussion in a planning type seminar. But from the court's perspective, we're not necessarily concerned about who becomes the representative payee. It's nice to know, for our purposes, who the representative payee is. It's certainly nice to know if there's been sort of a tug of war over who wants to be the representative payee, where Social Security really is not coming to the court to express what's gone on, but that information usually gets to us either through court-appointed counsel for the alleged incapacitated person, or if the court appoints one, through a court evaluator.
Okay, great.
That's more of a planning issue as opposed to an issue that's sort of indelibly linked to whether a guardian is needed or appointed.
Okay, so the question that just came in is there a scenario where you could request a guardian to relieve the burden of a loved one? So I'm guessing the question asker wants to see if the court would appoint like a third party guardian to relieve the burden of making those decisions from a family member.
Well, I mean, we're in a day and age where care for people who are going through the aging process has become an industry in and of itself. And most family members are now, there's coaching and there are resources to assist them because it's a very, very difficult process. It's draining not only physically, but it's draining mentally, and it drains your life. And your life ultimately becomes secondary to the life of the person for whom you're caring. And that's not necessarily the healthiest thing for you and for the person for whom you're caring. In the scenario that I'm seeing here in the question is, I'm assuming that there's no guardian in place and a family member. Again, you're not required as a family member to care for your loved ones. That's a social, it's a moral and a social issue as opposed to a legal issue. And if you aren't able to do it, many people have no spouse, they have no children, they have siblings, many of whom are afflicted with the same ailments that the person coming before the court has. And the court does have a roster of professional guardians that it can appoint who are trained in terms of what to do. Most of them are attorneys, not all, but the court has a roster of those people who are appointed. They get paid for the time that they put in as guardian, but they are well versed in what to do, and that can certainly be a scenario. It's usually a scenario when you have family members who are fighting over the entire situation, or you have agents that aren't acting under the advance directives that have been executed, and the court sensing that if we keep this in the family, it will be detrimental to everybody involved, particularly detrimental to the ultimately either person in need of a guardian or incapacitated person. that's when the court turns to that sort of third-party guardian, that neutral guardian to step in, who's a professional in every respect and will be able to navigate the toughest waters with other family members. That's what they train for that. And, the people who the court appoints with that in mind, that they're able to navigate their way through those difficult times.
And if the question asker's situation does not necessarily need a guardian, Westchester County does have the ISEP program, EISEP program, which is expanded in-home services. There's a sliding scale for cost. The program is run by Westchester government. And if someone needs those sorts of services, a referral can be made to 914-813-6444, which is the Westchester County Department of Senior Programs and Services, 914-813-6442. And we have another question that came in. How does the court look at one's living will and healthcare proxy when making a determination for guardianship?
Well, as I tried to suggest today, if the healthcare proxy is validly executed and the person who is designated as the agent, your healthcare agent, is indeed communicating with your care providers and communicating with any administrators in a care facility, if you are in one, and your living will is also properly executed and your wishes are set forth in terms of end of life type decisions, then there probably won't be a need for a guardian over your personal needs. Remember, the healthcare proxy and living will only address issues that go to or are attended to your personal needs and medical decision making. It has nothing to do with your finances. That's why when you're talking about a package of documents, I've mentioned 3. The power of attorney and that covers your financial transactions and your business transactions, and the healthcare proxy and living will cover your medical decisions, medication decisions, and ultimately any end of life decisions that have to be made on your behalf. So that's why you need to look at that. You can certainly, nobody's requiring you to go out and execute all those documents. But if you're having trouble maintaining a checkbook and you don't have a power of attorney, you may very well need a guardian for your property management. Even if you have a healthcare proxy, and even if you have a living will, that only means that you don't, or hopefully won't, need a guardian for your personal needs. But if you're still suffering from aging issues, which are affecting either short-term or long-term memory or your ability to carry out the financial components of your activities of daily living, it could very well mean that you need a guardian for your for your property management. And the court can appoint one or the other or both.
Terrific. So we have a very personal question that came in, but there's a component of it which I think we can address. So the question asker used an online New York durable power of attorney with no gift rider, which was then notarized, appointing the agent, and the bank will not accept the form. In terms of online forms, how does the court look at online forms that are self-executed?
The court really shouldn't say. Each of those cases turns on the individual facts of the case. Online forms, aren't the most reliable resources for you to use. People execute online forms usually because they're trying to save money, and that decision sometimes ends up costing them money. That's what I'll say on behalf of court personnel. Okay, so we can't really comment on the individual scenarios that arise, and there are many that have arisen of the like that I'm seeing and as Sarah just described. But again, a lot of that we hope will be alleviated with the legislature's implementation of the new power of attorney form, and more importantly, the legislature's implementation of a more strict scrutiny on the banks who have been refusing forms in the past.
Thank you, Joe. As we're approaching 10:30, and we are going to thank you for your time, because I know you have to get to court. If anyone has other questions, Bruce is going to show you on our website where they can. We'll be happy to address them after the program has been completed.
Thank you both. Stay well. If you have any questions, you can filter them through Sarah and she'll get them to me. It was a pleasure. Everybody stay well. Thank you.
Thank you so much, Joe.
You're welcome.
So I was just saying that the Ask Us button is right here. This is generally our website where we have a lot of information, including recordings of all of our webinars. This webinar will be up by Friday. If you want to pass the link along to a friend, the registration shortly for our next webinar on June 16th, and then June 30th will be right here. And then I wanted to just take a moment to thank our sponsors. So our sponsors have enabled us to move our programs starting in March 2020 to these virtual webinars. We also offer online consultations. So we have many attorneys, financial planners, care managers, and others who support us. So thank you very much. And
would you mind just clicking on the Ask Us button so we can show our participants how to ask us a question?
Okay, all right, so actually to click on it, sorry.
So if you have a question, you would just click on the Ask Us button and then see where it says submit your questions here. You would type your question, and then a little further down, you would put in how we should get back to you to answer that question, and we'll connect you with either our speaker today, Joseph Accetta, or we'll connect you with another member of the Senior Law Day Collaborative who can answer your question, especially the ones that are more specific.
Thank you very much, everyone, for your time, and have a great day. Take care. Bye-bye.